Welcome to AI Unraveled, your daily briefing on the real-world business impact of AI. Today, we pivot from deployment to defense. The autonomous capabilities of generative AI, from hallucinating content to designing novel drugs, have created a legal risk landscape that challenges every traditional doctrine of corporate liability, from foreseeability to product liability. This is no longer an ethics debate, it's a litigation ticking clock. In this essential special episode, we dissect the burgeoning regulatory dichotomy, the comprehensive risk-based approach of the EU AI Act versus the fragmented litigation-led system of the United States. We will analyze the central conflict of copyright law and the high-stakes lawsuits over training data, and we will equip you to defend against the threat of defamation by hallucination. But first, a crucial message for the enterprise builders. Stop marketing to the general public. Talk to enterprise AI builders. Your platform solves the hardest challenge in tech, getting secure, compliant AI into production at scale. AI Unraveled is the single destination for CTOs, VPs of Engineering, and MLOps heads who need production-ready solutions like yours. We have reserved a limited number of high-impact mid-roll ad spots. Secure your mid-roll spot. The link is in the show notes. Tune in to learn the only viable defense, a proactive governance-first strategy. Let's unravel the legal risks.
Welcome back to the deep dive. Today we're tackling a really big tension. Generative AI, it's moving so fast, so powerfully, and it's smashing right up against the legal system, which is, well, slow, built on precedent. And for anyone out there building AI, using it, investing in it, this clash is creating some huge, sometimes really fundamental legal risks. So our mission here is to sort of map out that risk landscape. We're going to look at the very different ways the EU and the US are trying to regulate this stuff, and then we'll break down these high-stakes court battles over copyright and liability, basically who's on the hook when AI goes wrong.
Yeah, and it's key to grasp why the legal system is finding this so hard. It isn't just that it's new tech, it's that AI fundamentally challenges, a couple of the bedrock principles of tort law. First one is foreseeability. Traditionally, negligence law asks, could a developer reasonably see this bad outcome coming? But with these autonomous models, they learn, they do unexpected things, emergent behavior, they call it. So the whole idea of predicting the outcome, it starts to get fuzzy.
Right. So if you can't reliably predict it, how does that hit the idea of negligence? It makes it harder to pin down, yeah.
Exactly. And that ties into the second big problem, accountability. Or maybe lack of it.
Ah, the black box issue. We hear that a lot.
Precisely. See, legal accountability demands explainability. A court, a regulator, they need to know why an AI did what it did. Why was the loan denied? Why was this person flagged? If the developer shrugs and says, well, the model is too complex, we can't trace the exact reasoning, how can you possibly defend that decision legally? The system's opacity is just fundamentally at odds with the law's need for transparency.
Okay, so those two things, foreseeability being tricky and the lack of explainability, it really paints a picture. It makes it pretty clear that, doing nothing, just waiting for the courts or Congress to figure it all out, that's not really a strategy, is it?
Not a viable one, no. It's just inviting way too much risk. The only sensible path forward for organizations is getting ahead of it, building proactive, integrated governance right into how they develop and deploy AI.
Okay, so governance is key. Let's dive into how different places are trying to regulate this then. Starting with the EU, seems like you're leading the charge.
Well, we definitely see this major split between the EU and the US. Two totally different philosophies, really. And that puts multinational companies in a tough spot.
Having to juggle both systems.
Right. The EU's approach is broad, it's prescriptive, very detailed. The US, much more market-driven, kind of a patchwork quilt of rules.
And isn't there this idea that the strictest rules, often the EU's, kind of end up setting the global standard anyway? The Brussels effect, right?
That's exactly it, because it's often just easier and safer from a risk perspective for a global company to comply with the highest standard everywhere rather than manage lots of different regional rules.
So that highest bar is definitely the EU AI Act.
Yeah.
Which just came into force, August 2024?
Correct. And the crucial part is its reach, its extraterritorial reach. Basically, if your AI's output gets used inside the EU, their rules apply to you. Doesn't matter where your company is based.
Okay, and that act uses a risk pyramid structure, I understand. Can you walk us through those tiers?
Sure. It's quite logical, actually. At the very top, you have unacceptable risk. These things are just banned outright. We're talking about government social scoring or AI designed to manipulate people against their free will, that kind of thing.
Stuff nobody really wants anyway.
Okay. Then the next level down is high risk. This is where most of the heavy regulation kicks in. Think AI used in critical infrastructure, hiring decisions, employment tech, medical devices, big impact areas. These systems need rigorous conformity checks before they hit the market, plus ongoing transparency duties, human oversight requirements, the works.
So basically, if the AI is making a decision that could seriously affect someone's life, their job, health, access to services, it's likely high risk.
That's a good rule of thumb, yeah. Below that, you've got limited risk. The main obligation here is just transparency. So telling someone they're talking to a chatbot or disclosing that an image is a deepfake, simple stuff.
And the bottom.
Minimal risk. That's where the vast majority of AI applications fall. Very few hard rules, maybe some voluntary codes of conduct encouraged.
Okay, that makes sense. But beyond the AI Act itself, you mentioned the EU is also shaking up product liability law, the PLD. That sounds like a really big deal for developers.
Oh, it's a huge deal, a fundamental shift. The revised Product Liability Directive, the PLD, explicitly expands the definition of a product to cover software and, crucially, standalone AI systems.
And why is calling AI a product so significant?
Because it triggers strict liability.
Okay, translate strict liability for us non-lawyers. What does that mean practically if someone wants to sue?
It makes it much, much easier for the person claiming harm. The claimant, the plaintiff, they only need to prove two things. One, the AI product was defective, and two, that defect caused their harm. What they don't have to prove is that the developer was careless or negligent. They don't need to show a lack of reasonable care. The burden shifts.
Wow, okay. That completely flips the usual script. And I remember there was talk of a separate AI liability directive, the ALD, but that got withdrawn. Did those ideas just disappear?
Not at all. They didn't vanish. The core concepts, especially the ones that really helped claimants, like this idea of a rebuttable presumption of causality.
Meaning the law assumes the AI caused the harm unless the developer proves otherwise.
Exactly. That kind of claimant-friendly idea and others like stronger evidence disclosure rules, they're being woven into the revised PLD and the main AI Act. So the spirit of the ALD lives on, making it tougher for defendants.
Okay, so that's the EU, comprehensive, risk-based, strict liability. Now let's jump across the pond. The US sounds like the Wild West in comparison.
Well, it's certainly fragmented. That's mainly because there's been no big federal AI law passed. So instead, you have existing federal agencies like the FTC, the DOJ, the EEOC. They're basically trying to apply their old rule books, policing unfair practices, preventing discrimination to this new AI technology.
And the real action is happening at the state level.
Very much so. California is definitely out front. They're using things like their existing privacy law, the CCPA, to mandate risk assessments for what they call automated decision-making technology, ADMT, and giving people opt-out rights. Other states are proposing their own rules, too. It's regulation by patchwork, definitely not a single coordinated design.
You mentioned something interesting earlier. Even with this fragmentation, there are proposed U.S. federal laws, like the AI-led Act, that also talk about classifying AI as a product.
Yes, exactly. That's the key convergence point. Even though the U.S. regulatory process is messy and state-led right now, the direction seems to be aligning with the EU on this critical point, treating AI systems like products for liability purposes.
Which brings us right back to that Brussels effect. If the U.S. might eventually land on product liability anyway, and the EU already has this super high bar with the AI Act, with those massive potential fines, like up to 7% of global turnover, why wouldn't a big global company just build to the EU standard from the get-go?
That's the calculation many are making. It's often just more efficient, less risky long-term to aim for the highest common denominator. Engineer your systems to meet the tough EU rules, and you're likely covered in most other places, too. So the EU standard effectively becomes the global default, even for companies not based there.
It's fascinating how regulation in one region can ripple out like that.
Yeah.
And it explains why we see maybe Canada or Australia trying to find some middle way, right? Focusing on high-impact systems or exploring different compensation models.
Precisely. Australia's focus on copyright, maybe looking at paid collective licensing for training data, that's another angle trying to address these core tensions.
Okay, that's a perfect transition. Let's talk copyright, because this seems to be where the most ferocious legal fights are happening right now. Generative AI models are built by, well, eating the internet, including vast amounts of copyrighted stuff.
Absolutely. And the main shield AI developers are holding up, particularly in the US, is the fair use doctrine. Now, fair use involves balancing 4 factors, but the real fight usually comes down to 2 things. First, is the use transformative?
Meaning, does the AI do something fundamentally new and different, with the copyrighted work beyond just copying.
Right. AI companies argue that training a language model on novels isn't about copying the novels, it's about teaching the AI grammar, style, facts, creating something entirely new, the model itself. That's their transformation argument.
Okay, and the counter-argument from creators, the authors, the artists, what's their main point?
They hammer on another factor, the effect on the potential market for the original work. Their argument is, if the AI can generate text or images or music that directly competes with what human creators make or could make in the future, then it destroys their ability to earn a living. It substitutes for their work. That market harm is the core claim.
But hang on, there's a huge catch here, isn't there? Does fair use even apply if the AI company got the training data illegally in the first place? Like from pirate websites?
That's a critical point. No, fair use is very unlikely to protect you if the underlying data was unlawfully acquired. If you scraped books from pirate repositories, used unlicensed images, etc., your fair use defense is probably dead on arrival. Which means organizations absolutely must have documentation, proof of where every piece of training data came from, and that they had the legal right to use it. Provenance is key.
So meticulous record keeping is non-negotiable. Now let's flip to the output side. What about the stuff the AI actually creates? Can that be copyrighted? The U.S. Copyright Office seems pretty firm on this.
Very firm. Their stance is clear. Copyright protection only applies to works created with meaningful human authorship.
Meaning if you just type a prompt into Midjourney and get an image back with no further creative input from you, that image can't be copyrighted.
Correct. Purely AI-generated works, where the human basically just pushed a button, fall into the public domain. We saw this established way back with the monkey selfie taste, believe it or not, and reaffirmed recently in Thaler v. Perlmutter.
Okay, but what about AI-assisted works? Like that comic book case, Zarya of the Dawn, where the author used Midjourney for the images but wrote the text and arranged the panels. How does copyright work there?
The human gets copyright protection, but only for the parts they creatively contributed. So in Zarya, the writer got copyright for the text she wrote and her creative arrangement of the panels, but the specific images generated by Midjourney, those were carved out, not protected.
Which is why the Copyright Office now makes you disclose if you used AI, right? So they know which parts are potentially uncopyrightable.
Exactly. Transparency is required for registration now.
This all leads to a kind of tricky situation for AI companies, doesn't it? You mentioned the George R.R. Martin lawsuit against OpenAI. Explain that operational risk.
Yeah, it's a real paradox. An AI company could theoretically win a fair use argument about its training process. They could convince a court that ingesting copyrighted books was transformative fair use. Okay, phase one defended, but the output from that very same model, maybe responding to a user's prompt, could still be legally infringing if it's substantially similar to one of those original copyrighted works.
So even if the training was legal, the output could be illegal.
Precisely. In the Martin case, the allegation was that ChatGPT could generate detailed plot outlines for sequels or prequels that were worryingly close to Martin's actual copyrighted stories. It's a separate potential infringement.
So the legal risk isn't just a one-time thing during development, it's ongoing.
Yeah.
With every single query, the AI answers.
Continuous risk, absolutely.
Okay, so beyond copyright, courts are also having to adapt existing legal ideas like negligence. How's that playing out with AI?
Well, negligence always comes down to proving someone breached a duty of care. What's changing is how courts define that duty for AI. They're starting to look towards established industry standards, things like the NIST AI risk management framework, as a benchmark for what reasonable care means.
So failing to test your AI properly for bias, or not warning users clearly about its limitations, that could now be seen as negligent.
Yes, increasingly so. Failing to follow best practices like those laid out in NIST RMF could be evidence of breaching that duty of care.
And what about the AI just making stuff up, hallucinations? Are those actual legal liabilities?
Oh, absolutely. They're not just quirky tech glitches, they are potential legal landmines. There was a case in Canada, for instance, where a company got dinged because its customer service chatbot gave a customer totally wrong information about a bereavement fair policy. The company was held liable for the chatbot's misrepresentation.
So if your AI confidently tells a user something false and the user relies on it to their detriment, the company can be sued for negligent misrepresentation.
That's the risk, yes. Hallucinations have real-world legal consequences.
But the biggest shift seems to be this move towards treating AI as a product. We talked about the EU PLD and the proposed U.S. AI Lead Act. Are U.S. courts already heading that way? even without a specific federal law yet?
They are, and quite quickly. There's a case from 2025, Garcia v. Character Technologies, which is seen as a bit of a bellwether. In that case, a U.S. court essentially said, yeah, this chatbot app could be considered a product based on how it's designed and marketed, allowing a product liability claim to move forward against the developer.
And if that becomes the norm, AI systems treated as products, it sets up a massive collision course with Section 230 in the U.S.
Yeah.
Right? The law that shields platforms from liability for user content.
Huge collision potential.
Yeah.
Section 230 is foundational for the internet as we know it. It protects platforms hosting third-party content. The argument against applying it to generative AI is powerful. These AI platforms aren't just hosting content someone else created. They are actively generating something new. The AI output itself is the product.
So the argument is they're creators, not just intermediaries.
Exactly. And if courts agree that this active creation means Section 230 immunity doesn't apply, well, that fundamentally rewrites the liability rules for every major AI provider. It's a potential earthquake.
Okay, so the risks are immense: copyright, negligence, product liability. Let's switch to defense. If you're a company facing potential litigation, what's the absolute must-have from an evidence perspective? Sounds like it all comes back to data.
It really does. And specifically, understanding the difference between two key concepts, data lineage and data provenance. They sound similar, but they do different jobs legally.
Okay, break those down for us. Data lineage.
Lineage is about the journey of the data. It tracks where data moves, how it's transformed, who accessed it, what processes touched it throughout its entire life cycle. Legally, lineage is your proof of process and control. It's the audit trail you need for privacy regulations like GDPR or CCPA. And critically, it's how you trace and potentially fix algorithmic bias. You follow the lineage back to find the skewed data source.
Okay, so lineage is what happened to it. What's provenance then?
Provenance is about the origin and ownership history. It's pedigree. Legally, provenance is your evidence of lawful acquisition. Did you have the right to use this data in the first place? This is your main defense against intellectual property infringement claims. It's where your records of licenses and permissions live.
Got it. Lineage, journey process, provenance, origin rights. Why is having both documented meticulously so vital in court?
Because you can bet that in almost any lawsuit involving AI harm, whether it's bias, IP infringement, privacy violation, one of the very first things the plaintiff's lawyers will demand is your complete end-to-end data lineage and provenance records.
They want to see the receipts, basically.
Exactly. If you can produce clean, detailed, auditable records, that demonstrates due diligence. It's a strong defensive posture. If your records are messy, incomplete, or just don't exist, a court is likely to look at that and infer negligence. It makes defending the case incredibly difficult, maybe impossible.
Which circles us back to the beginning. Proactive governance isn't just good practice, it's potentially your only viable legal defense. So wrapping things up, what are the concrete, actionable steps organizations need to be taking right now?
Okay, 3 key things. First, don't reinvent the wheel. Adopt a recognized, structured framework. In the U.S., the NIST AI Risk Management Framework, AI RMF 1.0, is the obvious choice. If you're operating globally, look at the international standard, ISO IEC 42001.2023, which is also certifiable. Use a roadmap.
Makes sense. What's number 2?
Treat AI risk as an enterprise issue, not just a tech problem siloed in data science. You absolutely need a cross-functional governance committee. Get legal, privacy, InfoSec, procurement, and your AI data science teams talking to each other, working together on policies and oversight. It has to be integrated.
And the third step looks like it involves pushing some risk onto vendors.
You have to fortify your contracts. When you're buying or licensing AI tools or platforms, insist on strong representations and warranties from the vendor. Make them formally state that their training data was lawfully sourced and that the system complies with relevant laws. And crucially, get robust indemnification clauses.
Meaning if you get sued because of their system, they have to step in and cover your legal costs and damages.
That's the goal. Shift that liability upstream where possible. Make sure your contracts protect you if things go sideways.
So framework, cross-functional team, strong contracts. It seems like a solid starting point. It's clear the legal ground under AI is shifting constantly, being shaped right now by these regulations and lawsuits. Being proactive, building that governance foundation, it's not just advisable, it sounds essential for survival.
It really is. And that leads to maybe one final thought to leave folks with, something a bit provocative. We're hearing legal analysts seriously predict the rise of what they're calling litigation as a service.
Litigation as a service, what does that mean?
Think about adversarial actors, maybe competitors, maybe activist groups, using generative AI itself to automate the process of finding potential legal claims and then mass generating and filing lawsuits or demand letters. Imagine hundreds, maybe thousands, of automated legal complaints hitting a company simultaneously, targeting alleged biases, IP issues, privacy slips, generated by another AI.
Wow, okay, that changes the game entirely. That means corporate legal teams wouldn't just be handling individual big complex lawsuits anymore. They'd be facing a constant high-volume flood of automated legal attacks, almost like cybersecurity threats.
Exactly. The required response framework might look much more like cybersecurity incident response, rapid detection, automated filtering, tiered response than traditional litigation management.
A shift from discrete case management to continuous threat defense. That's definitely something powerful to mull over. A whole new frontier indeed.
That wraps up our special episode on AI liability and proactive governance. The major takeaway is clear. Generative AI models, while revolutionary for R&D and productivity, are liability delivery systems if left ungoverned. The legal system is playing catch-up, and that lag will be filled by precedent-setting litigation. Your defense is not in hoping for regulation, but in proactive enterprise governance. You must establish robust data lineage, secure your external contractual safeguards, and treat every model output as a potential legal document. This is the difference between an investment that pays off and a liability that bankrupts. If you are leading an enterprise through this high-stakes shift, this message is for you. Stop marketing to the general public. Talk to enterprise AI builders. Your platform solves the challenge of getting secure, compliant AI into production at scale. We have reserved a limited number of mid-roll ad spots for companies focused on high-stakes governed AI infrastructure. This is a direct line to your most valuable buyers, the CTOs and VPs of engineering. Don't wait. Secure your mid-roll spot immediately. The link is in the show notes. If this analysis helps you build your strategic plan, please take a moment right now and like and subscribe to AI Unraveled. Thank you for tuning in. We'll be back tomorrow to unravel the next chapter in AI.